Thank you very much, and welcome back, everyone, after the break. It's very good to see so many of you. My name is Uta Steiger. I am something of a disciplinary parasite in the Faculty of Law. So I run the European Institute here as an interdisciplinary hub, and this is now located in the Faculty of Laws, but works across the entire university. But it's my huge pleasure to be chairing today's session here, which really cuts across several of the topics that we're interested in as well. So as you will have seen from the program, the session topic is on populism and threats to rule of law within the bigger context of climate change that you've been addressing today. And we have quite a variety of regional perspectives on the topic today, as well as a variety of professional and academic perspectives on it. And in light of that, I've also decided very last minute to change the running order so that we make sure we have a very integrated discussion of all the different perspectives. So I will have four speakers. Sanja Bogojevic from Oxford. I will then call on Astrid Puentes, who's a legal consultant, followed by Jeff King, and then finally Chris Hilton. And everybody's been asked to stick religiously to 15 minutes, and so that we have about half an hour discussions worth at the end. That also means I will stop speaking here right now and just very briefly introduce our first speaker, so Professor Sanja Bogojevic from the University of Oxford, who's a fellow and professor of law at Lady Margaret Hall and the Faculty of Law. And prior to joining Oxford, she was Associate Professor of Environmental Law at Lund University, to which she remains affiliated. And her research interests, not surprisingly, lie exactly at that interface of environmental law and EU law more broadly, so the European perspective here, and explores interlinks between the public and private spheres. And our topic today is the race for lithium and the rule of law. So over to you.
Great, thank you so much for the introduction and for the organizers for this fantastic event. So as said, the talk today is about lithium and the rule of law. And one of the questions that my talk, which is based on one of the key blog posts for this workshop, asks is, well, what does Novak Djokovic, the Serbian world #1 tennis player, have in common with net zero strategies and lithium? So you may think none, but in the course of this talk, we'll investigate the polycentricity of climate change and more closely the interlinks between net zero, the UK net zero strategy, battery-driven transportation, populism, and the rule of law. So let's start with the net zero strategy. So we have, as I'm sure everyone here knows, the Climate Change Act, which was revised recently with the ambitious target of reaching climate neutrality by 2050. And last year, the government produced its net zero strategy with suggestions or proposals and indeed plans for how to reach that target. So I feel that slide is testing my eyesight, so I will have to turn over here. And the foreword is interesting by the Prime Minister to spend just a little bit of time on to get a feel for what kind of ambitions or hopes are placed on the future. So Boris Johnson here talks about that the strategy shows how, it says that in 2050, we will still be driving cars, flying planes, and heating our homes, but our cars will be electric gliding silently around our cities. Our planes will be zero emission, allowing us to fly guilt-free, and our homes will be heated by cheap, reliable power, and so on and so forth. So this is very much a win-win kind of scenario, which we often find in net zero strategies, or kind of the green future, so to say. There is very little of the conflicts that climate action, in fact, creates. So if we look at, and this is my brilliant colleague, Liz Fisher, has written about the fact that climate action does create winners, but it also creates short time, or losers, at least in the short term. And we have many examples of these kind of winners and losers in the conflicts that climate action in fact creates. So here I've only illustrated 3, but there are obviously many examples. So perhaps the most famous one is the Yellow Vests in France, following fuel levies that affected communities in those more vulnerable socioeconomic communities the most. So that led to the Yellow Vest protests. Yellow vests have become a bit of a phenomenon, and we can see here they were also used by Polish protesters in protesting the Court of Justice judgment on the Turów mine case, where the coal mine was thought to be closed. So we also see them here. We also see the conflict in the UK. This is from The Guardian, a really interesting piece, a long read, on the issue or conflicts around airports in the UK. So there are actions for local airport expansion. So some local communities are largely in favor of airport expansion on, various grounds, but overarchingly for economic reasons, while we also have opponents to airport expansions, which are then branded as a climate elite that doesn't care about or is not affected by local economies as some other. So as Liz has pointed out in this piece that is listed on the slide, action on environmental law, but kind of climate change more specifically, helps fuel populism. So it's easy for populist politics to take advantage of the alienation that those on the losing side here in these conflicts may feel. So interesting to note, this is taken from Twitter. This is me trying to decipher Polish. But what is interesting here, it says that this demonstration before the Luxembourg court, that they were singing the hymn Polski. So they were singing kind of the national, sorry, my lens is playing up. They were singing the national hymn. So we see this kind of nationalist, populist rhetoric in these demonstrations. Okay, so clearly we know that climate action creates these kind of conflicts. So how come is the net zero strategy then so hopeful? So let's turn to lithium. So one of the reasons why it is hopeful is because of lithium exactly, or electrical transportation. So lithium is not a scarce resource, but it is a resource that is, or a mineral that is mined in only a handful of countries. So the biggest lithium producers include China, Australia, Brazil. And here we can see in the net zero strategy, it's talking about the fact that we need to ensure, so that let's see what it says here, that the demand for lithium will increase by 500% by 2050. So there's a huge demand. So it's not, the resource exists, but it's only in a handful of countries, and the demand will only increase. So this has then led the UK, but not only the UK, also the EU has identified lithium together with a handful of other minerals as so-called critical minerals. And it has become a security question getting access to these minerals. So the UK does have, I'll mention that towards the end, it does have lithium reserves. But in Europe, the biggest lithium reserves to date that have been identified are located in Portugal, Spain, Finland, Austria, Czech Republic, and Serbia. So we're getting closer to Novak Djokovic. Okay, so let's see. We're getting there. Okay, so and so Rio Tinto, which is the Anglo-Australian mining venture conglomerate, it identified lithium in Serbia already in 2004. So a pretty relatively long time ago. The lithium is found in western Serbia, And he says that this is one of the largest lithium projects in the world. And this is not in this exact quote, but it's in the blog, it estimated that it would be able to feed 90% of EU's lithium demand. So it's a huge reserve. And this would also become, by granting access to lithium in Serbia, Rio Tinto considered that it would become one of the world's biggest lithium producers. So Serbia was identified as an important investment opportunity. So what here is interesting to note is that the first permit that was given to Rio Tinto was already in 2004, so long before the current populist president came to power. However, the current government is very much in favor, for economic reasons, to support Rio Tinto's investments in Serbia. So what it did in November 2021 was that it suggested a series of amendments to the laws of expropriation, which were understood to allow foreign companies such as Rio Tinto, but Rio Tinto not alone, so Serbia also has a lot of Chinese investments. So the private investments to exploit mineral resources with limited opposition from local communities. So according to the Serbian constitution, private property may be expropriated, but only in the public interest. So what the proposed new legislation did, or was intended to do, was to change the public interest to something called projects of special importance. And what projects of special importance actually meant was not qualified, so it would be left to the executive to decide. So what we've seen here is a vast allocation of power to the executive on expropriating private property. So this led to mass protests, and we see this is from The Guardian in Serbia, started following the proposals. And with the presidential elections in Serbia coming up, so in fact they're taking place on Sunday, what the president decided to do was to withdraw the amendments and also say that and revoke Rio Tinto's permits with the decision to hold a referendum on the future of Rio Tinto until after the polling date. Okay, so what do then these three, coming back to kind of the initial question, so why do we care about this story and what does this have to do with climate change and the rule of law? So a couple of things to note here. So what this short story tells us is that net zero strategies are not straightforward and that the win-win rhetoric is misleading. So what is more, the strategies may lead to conflicts that endanger the rule of law elsewhere. So the stakeholders to these conflicts, just as climate change itself, are polocentric. So even if the UK net zero strategy creates no environmental costs or other costs on British shores, those costs will be carried by communities elsewhere that may lead to populist instability. What is noteworthy is that populist politics insists, and this is something that I've written about before, on formal and procedural ideals. But under scrutiny, what we see here with populist rhetoric, and I don't have that much time to explore that today, but happy to chat about it, is that undercurrents of rule of law erosion is prevalent. So the Serbian example of amendments to the appropriation laws is just one such example where we see populist rule kind of sticking to procedure, but actually kind of quietly cutting away on rule of law protections and ideals. It's also an example of how the narrative, or the populist narrative on climate change is changing. So this is not to say that populists have changed their view on climate change. They tend to question it or even believe in it. but they have found a way to blend climate change into their political message. So a core feature of the populist narrative is to separate the people from the corrupt elites. In here, the corrupt elite is easily seen as those who don't care about the impact that climate action results to. So the president, and this in a sense fits very nicely into the Serbian example. So the president was insistent on the fact that he had changed the course on lithium mining in Serbia very much on his own accord, and in order to hand back the question to the people. What is also interesting is that he disregarded, or the entire government disregarded, that he had done so as a result of the pressure that the demonstrators caused. So they identified NGOs and demonstrators very much as politically motivated. And this is, again, a kind of a classical feature of populists. NGOs are a threat to their kind of illustration of them being the leader of the people. So the Serbian example of climate conflicts was resolved, so to say, at least for the time being, on the streets. So this may have had the favorable outcome, as thought by some, that the permits of Rio Tinto were revoked. But it leaves very limited guidance as to on which ground did, in fact, the permits revoked, on which grounds did these amendments were actually withdrawn. In a sense, this is a question about participation also, and it also leads to kind of further fueling of populism. So one interpretation of what had happened in this specific context was that the Serbian president had in fact stood up to Jovan Knokovic, who is very much kind of thought of as the national hero, in light of his revoked visa to play in the Australian Open. So this is my kind of final point on this issue, is that with regards to net zero strategies, and just an example taking lithium, we need to think about how these conflicts are resolved, by whom, and on which grounds. And it's not just a question for Serbia. So as I said, lithium and problems with lithium have been found across Europe, including in the UK. So there are lots of questions for environmental lawyers, but lawyers more generally, to think about with regard to net zero strategies. Thank you so much.
Thank you, Tanya, wonderful. Also, big thank you for being the first speaker and sticking to time, which sets a wonderful example. And very, very rich insights, obviously, on a specific, in this case, European example, which we're now counterbalancing with a view really, probably, I would expect, more on the inter-American and American side of things. And for this, we're joined by Astrid Puentes, who's a Colombian attorney and independent legal consultant, and formerly also the co-executive director of the Inter-American Association for Environmental Defense. And she will speak on climate crisis, the banana republics turning into fossil fuel republics, and why climate justice matters. And Astrid joins us online. Astrid, thank you and welcome.
Thank you. Thank you very much for this invitation. And it's a pleasure to be participating in this conference, hybrid for now. It's really good to talk about this and thinking about what I want to share with you about why talking about banana republics and climate change matters. Really speaking after lithium and all of what we just heard, it's key because we also have a lot of problems with lithium in Latin America. In Bolivia, for example, recently there was a few years ago, there was a coup that Elon Musk, specifically on a famous Twitter, said that he backed because of lithium, because Bolivia is one of also the largest countries with these reserves. There's a lot of conflicts in the north of Mexico with lithium also. So we definitely are talking about things that are related. It's not only in Europe, and it also has to do with a lot of the work that we're doing. And so going and talking about these banana republics or the fossil fuel republics, wanted to share this with you because for those that do not know, banana republics are, to me, a painful concept that was used to call republics in the tropics because of the lack of rule of law and the corruption and human rights violations that happened around the production of especially banana, but other tropical fruits as well, linked with the United Fruit Company. That was a US-based company that operated in a lot of countries. And one of the things that happened was the massacre of what apparently was hundreds of people in Colombia in 1928, in a massacre that is included in a lot of books, including 100 Years of Solitude, one of the books from the Nobel Prize, Gabriel Garcia Marquez, but that still a lot of people in Colombia deny. And so one of the things that we are seeing today with mining companies and fossil fuel companies is whether the way that they are influencing public policy and denying climate change or delaying also climate action makes me think about whether we are seeing fossil fuels republic and whether that is actually limiting an obstacle to all the changes that we need for climate action. And I know that it sounds both horrible and sad, but also might be extreme, but seeing the lack of climate action, not only in Latin America, but in the world, the GAP report from the UN annually shows the numbers that are increasing still in terms of emissions. We know that the NDCs combined, even if they're all complied with, will brings us to a planet with a more than 3 degrees centigrade of increase in temperature. So that's one of the things that and I think it's very important to think about, also linked with the level of the impact and who is today living and suffering most of the impacts. And so with that, I picked 2 examples. Again, as I said, we could continue talking about lithium. I selected a couple of examples about other things that reflect how we're still seeing the fossil fuel industry prioritizing interest in the rule of law and in policies in Latin America and elsewhere. One example is from Mexico, that the Constitution was amended in 2013 in an amendment that was seen as a very positive one because it's related to the electricity reform, and the idea was to modernize that sector, specifically as it was argumented and communicated. The idea was to modernize the sector to increase and promote renewable energy, which was very important, and it is one of the key things that we need for climate action. The problem with this was that in between that amendment, there's a provision that was approved that it says that it's boosts energy transition and also prioritizes the use of all the soil, the land, and also subsoil for oil extraction and all other uses related with hydrocarbons. So it's in 2013 when already we were acknowledging and negotiating the Paris Agreement, for example, when Mexico in theory was a leader in climate action. We see this, that it's included in the Constitution, prioritizing the use of the soil and subsoil to all things that has to do with the oil production, which it has a lot of problems. And of course, one of the things is that it is according to the Constitution, it prioritizes the use of the land, for example, over conservation, over the food production, over conservation of fresh water and other aspects, including the protection of indigenous rights. And this was done by an administration previous to this one. But it has been very useful for this present administration that has one of the objectives is to prioritize the recovery of the oil sector. Which again, of course, as it's obvious, but I will say it, it's against all the climate action and efficiency and the transition that we need. One of the examples of this has been to rescue the Pemex, that is the national oil company, that is one of the biggest oil companies that has produced, is responsible of global emissions. It's one of the companies that is listed in this Carbon Majors research. And that has meant that over the last years, Pemex and the national government has increased fossil fuels in things like building a new refinery that is called Dos Bocas in Mexico, in Tabasco, that is one of the states that is more vulnerable and impacted by climate change. And also Pemex recently last year bought a refinery from Shell. Interesting enough, the announcement of the new refinery, the Pemex buying the refinery from Shell, was done days before the decision from the Dutch courts calling Shell to reduce in 45% their emissions. So one of the things that we're seeing here is that the risk of all the emissions that are being caught in the north, in this case in the Netherlands, now being done by the south, by Mexico's Pemex, which is something that we definitely have to cut. The other example is in Colombia with fracking. And this is key also to have in mind because Colombia has been recently communicate themselves and in several spaces, including in the UNFCCC negotiations, being called a climate leader, which is not a climate leader. The climate policy in Colombia is full of inconsistencies. And one of those is increasing gas production and with fracking, for example, even against the rule of law. Colombia has been trying to advance on fracking for a few years ago, and because of the risk for health and the environmental impacts and also the impact on water and climate, there has been a lot of litigation. And in 2018, the Council of State, which is one of the highest courts in Colombia, suspended all fracking because of all of these risks based on the precautionary principle. And of course, this was something that both the companies and the government of Colombia didn't like, and they've been trying for 4 years to push against this decision from the highest courts. And recently, on March 25th, there was a regulation approving pilot projects, which is a way to go around the suspension of the highest court, around the rule of law, around the decision of the judiciary, and go forward with fracking that will start very soon. And so this, again, not only puts in risk the rule of law because it denies the separation of powers, a decision from a highest court that is based on the protection of human rights, but it also prevents the climate action and the transitions that we need. And with this, I want to close and mention why climate justice matters and why climate justice can help us strengthen the rule of law. As several communities have been saying for years, really, and indigenous peoples and a lot of environmental and human rights lawyers that have been working on this, we need to make sure that climate action is done with people and human rights and nature at the center. It's already included in the Paris Agreement, and yet it's not saying in the center of the climate action. We're seeing that with the difficulties that in the last, in general with the UNFCCC, but specifically in the last COPs, has been to include human rights in the negotiations. And yet we're seeing that even the IPCC has said that climate action needs to include human rights and equity and justice at the center, and also consider indigenous peoples' knowledge, for example. Why? Because as we are seeing, and as I mentioned before, all the climate efforts, all climate action today is not being effective and efficient as it has to be. And so the part that is missing there is really including human rights at the center so that we can find the solutions that we're not seeing, control corporate power and corporate capture that we're also seeing, and that is threatening the rule of law. And so that we can see that the rule of law really advances human rights and the profound and structural changes that the world needs. One of the things that we are seeing, as I mentioned, with the refineries that Shell is selling to Pemex and the fracking that is being banned or prohibited in a lot of places like the UK and some states in the US and France, we're seeing an increase of fracking and the pressure of companies to implement fracking in Latin America because it's seen as green energy, which is not. And gas is part of the 3 fossil fuels that we need to stop. So this is the kind of things that it's important to highlight in terms of how to make sure that climate justice is actually at the center, and how we can make sure that the rule of law is part of the profound and structural changes that we see, so that it includes and is aligned with the climate objectives and the actual guarantees and compliance with the protection of human rights, that also advances equality and justice, which is something that we're also seeing as the Special Rapporteur on Extreme Poverty mentioned a few years ago about the climate apartheid. So making sure that climate justice is at the center, that human rights is at the center, that we're actually advancing climate action towards the solutions that the globe needs, and not, as we were saying before, with structures like the climate zero, or advancing energy that is maybe can be with less emissions, but it's not actually advancing the reduction in emissions and the solutions that the planet needs. Thank you very much.
Thank you very much, Astrid, for this wonderful perspective and call to action, really. So we've had now 2 perspectives that were very much centered on specific regional examples, although with principles that we can extrapolate from it. So now we're turning to a third perspective, in-house again, if you like, in a double way, that's probably looking towards a more kind of abstract and theoretical way of understanding the conflicts that are at the heart of the tension here. So for that, we're turning to Professor Jeff King, who is from here, is a professor of law at UCL, who has particular research interests in UK and comparative public law, including international law, but also constitutional theory and socio-legal studies. He's also visiting professor at the Faculty of Law in Oxford, and was, among many other things, between 2019 and 21, a legal advisor to the House of Lords Select Committee on the Constitution. And he will turn to a consideration of how populism poses a threat at one and the same time to sort of 3 competing sources of legitimation for decision-making: the values of the rule of law, expertise, and democracy. So over to you, Jeff.
Thank you very much, Uta. So I want to make a simple argument in my paper today. As the title of the talk indicates, populism, as I will come to define it, is in plain tension with the values of the rule of law, technocracy, or expert governance, to put it in a more charitable light, and representative democracy. I want to add to that argument that each of these other 3 values can also compete with one another in public discourse, and that tension can lead inadvertently to some sort of divide and conquer strategy or outcome, one in which those values are deployed against one another and can weaken governance frameworks in the process that inadvertently can fortify populist styles of governance and critique. Now, I don't see a silver bullet for the problem of the competition between the rule of law, expert governance, and democracy. But the one thread that I see as holding these three values together in a single coherent vision is the affirmation of the importance of the state in modern governance. And I'm going to make the argument that the idea of the state as a locus and guardian of the public polity is a value that an idea that those three values can affirm and ought to affirm. The affirmation of those three values, furthermore, is something that needs to be urgently done because it is precisely through the rule of law, technocratic governance, and representative democracy that we'll have any hope of addressing the climate crisis properly. So in the remainder of my time, I want to discuss what the meaning of populism is, tension between populism and these three values, which I don't think will be require too much time because it's fairly plain, disagreement between those three values, and how that disagreement can be resolved beyond the claim that they should all affirm the value of the state. So as to the meaning of populism, there's been a tendency in writing about populism and constitutionalism recently to emphasize that there are actually varieties of populism and not all of them are problematic. An example of this writing can be found in the work of the constitutional lawyers Mark Tushnet and Boyan Bugarek, who contend in their book Power to the People that populism can be both left and right-wing. They contend for a stripped-back notion of populism which has essentially two features. One, that there should be a strong relationship between political majorities and policymaking, and the other, that political majorities should be understood as being composed of the ordinary people. Now that idea of populism is significantly less insidious than some of the other versions of populism, and probably the one that we have in mind here. And it's also, superficially at least, more tolerant of views of populism that could be pluralistic, democratic, institution-supporting, constitutional. In an essay for a forthcoming Cambridge Companion to Constitutional Theory, the scholar Paul Blocher will argue in a similar vein for a less normatively loaded and constitutionally accommodating understanding of populism. For my part, I feel that this kind of approach to populism tends to water it down and could conflate it with the simple idea of democracy itself. So I tend to lean more towards the direction of the majority of commentators on populism that see it as inherently antagonistic to constitutional values. Jan Werner Müller's pioneering book, What is Populism, is a leading account that should be begun with, and I think really gets the account accurate. So Müller contends, and I'll quote from him here, that populism is a particular moralistic imagination of politics, a way of perceiving the political world which opposes a morally pure and fully unified, but he argues fictional, a morally pure and fully unified people to small minorities, in elites in particular, who are put outside the authentic people. Apart from this criticism of elites, however, there's an additional element of populist discourse. Populists necessarily claim that they, and only they, are properly representative of the authentic, morally pure people. So populists, he's saying, are not just anti-elitists, they also need to be anti-pluralists. And this is the part of his quote that I have in bold type. The claim to exclusive moral representation of the real or authentic people is at the core of populism. Political actors that are not committed to that claim, he says, are not really populists. I tend to agree with him in that analysis. Wojciech Sadurski, a great Polish constitutional theorist, has this to say of it. Populist regimes are impatient with freedom of speech for minorities. They dislike slow, patient deliberation in parliaments. They prefer a winner-takes-all plebiscitary model of politics under which the leader, usually a charismatic leader, obtains a carte blanche for the period of his or her parliamentary or presidential term. At the core of this brand of politics exists the idea of the will of the people. And the political scientist Albert Wheel, also of UCL, has written an excellent short book on this topic, calling it a modern myth. I would commend it to anyone. So, as for the meaning of populism, I'd say shorn of the qualifications, it's fair to argue that populism stands for a brand of politics that rejects pluralism, rejects checks and balances, and is skeptical of elitism. It's a totalizing narrative of what the interests of the people are. So what is the strain then between populism and those other three values I was talking about? Well, put most briefly, populism not only derides institutional checks and balances on the democratic character that is supposedly represented in the populist leader, but it treats the existing institutions as having been permeated by illegitimate interests. These interests could be those of landed wealth, corrupt elites, or communists or leftist rent seekers. The result is, though, that the institutions are not only democratically illegitimate if they stand in the way, but that they should be swept away or radically reformed because they're rotten to the core. That kind of populism is plainly in tension with the rule of law. Populists are keen to treat legality as a nicety that poses a constraint on the democratically exercised legitimate will of the people. Experts, furthermore, represent the interests of elites. They were schooled in elite institutions and chosen by elite politicians and insulated from popular oversight. And democratic institutions like legislatures and agencies are themselves denigrated as talking shops that hamper the execution of the authentic democratic will. You can witness how Parliament was so characterized in the Brexit crisis, especially in 2019, and by the rhetoric of President Donald Trump describing Congress as a swamp that needed to be drained. So all these constraints are stigmatized as the bequest of a rotten political order that lacked legitimacy, or a form of sclerotic and corrupt bureaucracy that prevents needed action from taking place. So the very idea of the state here, in other words, comes under direct attack in this mode of politics. In the US, the administration of President Trump promoted the idea of the deep state. In South Africa, President Jacob Zuma sought to carry out what was called by his critics to be state capture there, and that was done by stacking oversight bodies with corrupt loyalists. And of course, in the Third Reich, the Nazification of the entire social and political order was an overt goal, largely carried out, and was considered revolutionary and totalizing rather than just continuing the existing state. So the tension between populism and those constitutional ideals I mentioned is plain. But what about disagreement between populism's enemies, as I'll put it? It might be thought that populism would have a lot of trouble overcoming the combined argumentative weight of the rule of law, expert government, and representative democracy itself. But it's assisted in that work of overcoming them by strained relations between those three values. For instance, there's a long and hostile relationship between the rule of law and both expert government and democratic majoritarianism. I alluded to some of that this morning in my talk. Let me relate one example in the history of that antagonism, which occurred in this country, which was the critique of delegated legislation that occurred in the beginning of the 20th century. So in a book called The New Despotism, the Lord Hewart, who was Lord Chief Justice in 1928, put forth a withering critique of both expert administration and delegated legislation. In this publication was actually serialized in magazines at the time. This was no minor figure, Lord Hewart. He took silk in 1912. He entered Parliament as a Liberal MP in 1913, was Solicitor General in 1916, eventually Attorney General, and then Lord Chief Justice of England and Wales. His book, The New Despotism, had a sensational impact on the UK and was the cause of appointing the Donoughmore Committee on Ministers' Powers to investigate the problems that he had outlined in that book. And the book caricatured what he called the creed of the ardent bureaucrat, the amateur of the new despotism. This civil servants he was talking about clothed themselves with despotic power, that the creed supported the view that the only persons fit to govern are experts, and the only obstacles in the way of governance by experts was the sovereignty of Parliament on the one hand and the rule of law on the other. These are the two key constitutional principles of that time that here the Lord Chief Justice is pitting against the creation of delegated powers, which were essential to the modern administrative state. So he continues on in a mocking tone. This kind of fetish worship of these ideals of expert governance is prevalent among an ignorant public. And so the expert thinks that the expert must use the sovereignty of Parliament to destroy the rule of law. As a commentator on this report, the political scientist William Robson described it as a violent and undisguised attack upon civil servants. Now, this wasn't just happening from conservative circles. At that time, Harold Laski published a pamphlet for the Fabian Society called The Limitations of the Expert. It was in 1931. And a similar critique of bureaucracy was taking place in the United States at this time. This is around the beginning of the New Deal. The American Bar Association was opposed to developments under the New Deal, saying that they entailed unconstitutional delegations of lawmaking power from Congress to agencies, and that those powers furthermore violated the rule of law and constitutional rights protections. Now, if you think that's interesting history, thank you very much. It's not like that anymore. I beg to differ. So these kinds of arguments actually have common cause with certain elements of the current Conservative Party in the UK Parliament. So Steve Baker, an MP, and Mark Harper, MP, both of whom are, and from as far as I can tell, very nice people. They were among the fiercest critics of the use of COVID-19 regulations during the pandemic. They argued that these regulations lacked appropriate democratic oversight, were contrary to the rule of law, and their proposed responses, in my view, as someone who spent a lot of time looking at the COVID-19 legal response, would have really hobbled the state's ability to respond to COVID-19 quickly and effectively. So there is a tension there. It's played out over the course of the history of the administrative state. Is there any room for reconciliation? I didn't get in, by the way, I didn't get into the tension between the rule of law and democracy, but that's a familiar theme for any student of public law, I think. What could be said of the reconciliation? So I think that the problem we need to be wary of is that the arguments that are sometimes used in one camp, let's say the rule of law camp, can have strong resonance to the arguments used in populism. So the rule of law advocates have historically been suspicious of state power and consider expert governance as nothing more than elite capture. Democracy advocates might join populists in castigating judges as out of touch and elitist, or bureaucracy as entrenched and obstructionist. Consider the show Yes, Minister for a moment in that regard. So we would want to keep the critiques within these three value camps of those other values of technocracy and democracy and the rule of law, respectively. We would want to put those critiques as carefully as possible. Now, I think that the arguments in these camps, and I take the example of political constitutionalism as such as a case, are at risk of being weaponized by populists. Political constitutionalism has advocated a long-running critique of courts and the rule of law, and their arguments in that respect were essentially co-opted by quite conservative political forces in this country. So how can we affirm those three values in a functionally symbiotic way while also rejecting the style of populist politics that I began with criticizing? My view is that one can do this by affirming the role of the state within each conception. More specifically, I think that the rule of law ideal should not be one that's contemptuous of democratic authority. It should give pride of place to the role for statutes and respectful of good administration and the role of public officials within it. Vague law is essential to the modern administrative state, and a watchful judiciary that is not skeptical of power in general, but is also vigilant about abuse in special cases, is essential. Now, I think that most administrative law in Europe gets that formula about right, but the constitutional theory behind the rule of law doesn't necessarily. I'm aware that I have only I won't say how much time because I'll probably go over, but I'll... I see, okay. Secondly, the idea of democracy should be a pluralistic and deliberative one, one that affirms the role of parties, that recognizes that democracy exists over time and that previous democratic choices are consolidated in statutes and in the institutions of governance that are recognized in Parliament. And thirdly, that administration can and should welcome public participation and democratic and legal oversight, as I happen to think most senior administrators do welcome both democratic and legal oversight, because owning decisions of such importance as the ones they're making tends to be fairly stressful. It's nice to have others come into that decision making with you. I'll stop there. Thanks.
Thank you very, very much, Jeff. And not to worry about running over, we have started a little late. And it is important to, I think, grasp all the three kind of important conclusions that you've outlined, and which I hope we'll be able to touch on in the discussion. Before we do so, we have one final presentation again, joining us online from Professor Chris Hilson, who is Professor at the School of Law at Reading. And he joined that from the Environmental Services Association, where he had been active for a short time as a policy advisor to the waste industry, so both an academic and formerly a practice angle to the question. He was also a priorly lecturer in law at Leeds, and he too obviously has particular research interests in environmental law and policy, climate law and social movements, which also comes in very prominently today, because he will now look at climate and the Court of Justice in the EU, so EU judicialization of politics, populism and the rule of law. Chris, thank you very much. Over to you.
Great, thanks very much, and very good to be joining everybody. Okay, so in the paper today, I want to be looking at a couple of really important EU climate litigation cases. The Carvalho case, or the People's Climate case as it's often referred to as, and also the Sabo case. And these two cases are ones that I'm going to be trying to illustrate using a constitutionalism lens, and one that takes into account different theories of constitutionalism, but also discusses the rule of law and populism alongside that. So I want to start by just, I suppose, identifying what the main argument, or one of the main arguments of the paper is. And it's really that there's a sort of double standard at play here with the Court of Justice. We all know, well, students of EU law all know, that the Court of Justice is really well known for having constitutionalized the treaties, so to speak. And it did that in the famous Van Gent and Loos case, by creating rights for individuals that they're able to enforce in their national courts against the member states. But, you know, and in doing that, as I'll come on to a little bit later, it's been accused of engaging in a judicialization of politics. Why? Because it's using the kind of secret language of law as a mask for pushing through what are really kind of quite significant political changes within those member states. You know, and that's the kind of classic story from the literature on, you know, integration through law, Euro-legalism, all of that kind of work. But it's a story that really only plays out vis-a-vis the member states. And the court has been very reluctant to encourage a similar kind of judicialization of politics, if you want to put it in that way, within its own court, and in relation to the choices not of the member states, but the political choices of the EU political institutions at the federal level, if you like. And I think the recent case law, this climate change litigation case law, the Carvalho and Sabo case, which we'll see, really kind of died in the water because they were rejected on standing grounds. Those cases and that declaration by the court, reaffirming its previous case law that there was no standing in these cases, really saw the court closing off that ability to constitutionalize its kind of own sphere of influence. So the paper outline roughly is to think about briefly what we mean by populism, but Jeff and others have already done a great job of that, so I'll skip that quite quickly. Then I'll think a little bit about the rule of law. Again, we've heard quite a lot about that, but I'll say a little bit about what I think perhaps we haven't covered yet today. And then I'll spend a little bit of time looking at that difference, which again, I think Jeff alluded to quite nicely in his paper when he was talking about the relationship between rule of law and democracy, which he said he wasn't focusing on. Well, this raises the kind of classic constitutionalism arguments between legal constitutionalists on the one hand, these are people like Trevor Allen, Ronald Dworkin, very keen on rights and the courts as a check against the political institutions and majority abuse of power, and political constitutionalists, people like Griffiths and Richard Bellamy at UCL, for example, who are much less keen on courts and rights and much more keen on democratic legislatures and emphasizing those as playing having the top dog role, if you like. Where does populism come in? Well, yeah, it's partly to analyze how some of those core elements of populism that Jeff's already outlined, this idea of the people and the elites in particular, how that plays out in some of these debates and some of this framing that we see used in this area, such as judicialization of politics and also government of judges. Okay, so populism is very much an ideational strategy. It's a political strategy, which, as Jeff mentioned, can be used by left or right. And it has a number of key features. Many of these features are ones identified by Muller and others, an author that Jeff mentioned. And you can see on the slide there that the idea of distrust of elites is there, and an emphasis on the real or authentic people is there as well, and also that kind of idea of anti-pluralism. One thing that, and obviously, left and right populism will emphasize different elements of that to varying degrees. One other thing that I'll come back to that I think is a feature of populism, which we've heard, I think Sanya mentioned this, was there tends to be a kind of carelessness with rules, because rules and parliamentary procedures as part of that, as well as Jeff mentioned, they slow things down, and rules are a kind of check on what the great populist leader thinks that the people really need, and rules can be apt to get in the way of that. So there's a temptation to think, well, okay, well, let's get rid of the rules then, because they don't apply to us. They're really only for other people. I think that'll be important to what I'm going to go on to say about the cases as well. Okay, so I mentioned legal versus political constitutionalism a little bit earlier, but I want to come on to I suppose, layer on top of that ideas of liberal and republican constitutionalism as well, because you can find, for example, that liberal constitutionalists are often legal constitutionalists at the same time. Trevor Allen would be a classic example of that. Ronald Dworkin would be another. But with republican constitutionalism, we can find some that are political constitutionalists. Richard Bellamy falls into both camps, but some like Philip Pettit, for example, and I would also place myself into this camp, they're Republican constitutionalists, but nevertheless are quite keen on rights as well as responsibilities, very often, much more so than a political constitutionalist would be. And the reason for that emphasis on rights and that kind of keenness on rights is because they want to pull this back to, if we're thinking about the rule of law, why the rule of law is important. And I don't think we've heard much about that today, actually. What's, the rule of law as an aim. And obviously a lot of political theorists of liberal and republican persuasion would say, well, it's really important because it's designed to support individual liberty so that people can go about living their own lives without arbitrary interference by the state or potentially by large corporations as well, as we've also heard today. So I think, you know, a lot of the elements of the rule of law are there in order to secure liberty in that sense. Okay, so I think if we're thinking about judicial review and its relationship with constitutionalism and the rule of law, we can distinguish broadly then between two types. There's a strong form of judicial review where rights are able to trump, if you like, democratic legislative preferences, and legal constitutionalists, and with their emphasis on rights, are very keen on that, and they would see that that expression of rights, that implementation of rights, enforcement of rights, as being an example of the rule of law at work. Those rights are law. Political constitutionalists, in contrast, favouring much more the democratic legislatures, are apt to believe that, well, if you give judges the last word on things, then you're just swapping one form of potential arbitrary interference for another set of arbitrary decision makers, because judges are not special. You know, they're just as prone to arbitrary decision making. And in fact, by giving the ultimate power to judges, what you're effectively doing is you're giving judges, you're putting them into the realm of politics, in effect. And those political decisions should be made by democratic legislatures. Okay, so that kind of foray into judicial review is important, because obviously the Carvalho and Sabo cases, these two EU climate litigation cases I'm looking at, are obviously judicial review cases. And we come on now to the standing element, which was at the heart of those cases. Well, here, again, you can draw a very kind of quick and dirty divide between Republican legal constitutionalists like Pettit, and I would put myself into this camp, who think, well, let's have broad public interest standing, make standing as broad as possible, you know, have an actio popularis, because if you're trying to keep a check on arbitrary government action, because that's important for freedom, you want the gates to the court to be as wide as possible, so that that arbitrary action can be kept in check as widely as possible. You know, you have a lot more kind of police officers keeping a check, if you like, as a sort of private citizens' army there, keeping a check on things. Liberal legal constitutionalists, on the other hand, like Trevor Allen, think that, yes, it's fine to have people with rights coming along to court, and they should have access. But if you open up standing to NGOs and interest groups who are not in possession of rights, so if you do have an actio popularis, then you're opening the courts up to politics in that case. And Allen, for example, would see that as illegitimate. Okay, so while we're on the rule of law, the next slide distinguishes, and this is a common distinction in the rule of law, between thin and thick versions. The thin version we've heard quite a lot of today already. That's the kind of, you know, the various principles you'd expect the rule of law to fulfill, such as, you know, legal certainty, non-retroactivity, and so on. Those are all important for freedom, and you know, whether you're talking from a liberal or a Republican perspective. Thick versions tend to say, well, you know, a law can only be properly considered to be in accordance with the rule of law if it's also respecting human rights. And therefore, thick versions of the rule of law tend to be associated with legal constitutionalists who are keen on rights. You know, your Dawkins and your Trevor Allens of this world. Okay, so we move on now to look at some of those elements from within populism. And I mentioned the people and also elites. Well, historically, judicial review, you know, if you go back to the New Deal era in the US, if you look at Anuj Bhuwania, who's a speaker on you know, the conference at some stage, he looked at post-independence in the Indian Supreme Court. A lot of courts globally have been quite regressive, actually, and they've used property rights as a constitutional right to hold progressive legislative programs in check and to hold them back. So they haven't served the people well from that point of view. They've served the interests of elites, usually propertied elites, who are the holders of those property rights. The Court of Justice, in contrast, in terms of the Van Gent case, and that idea of constitutionalizing the treaty by creating rights for citizens that they can enforce in their national courts, I think, commentators have said, the court sees itself as a people's court, because it is creating rights for the people. But as I say, I think it's a slightly one-sided argument, that, because it falls short when it comes to direct judicial review actions under Article 263, where citizens are not bringing claims against their member states, but they're trying to bring claims against the EU institutions themselves. Okay, what about elites? Well, we've just heard that elites often try and use law to their own ends. And Rand Herschel, well-known constitutional theorist, says, elites are often trying to mask what they're doing, which is actually politics. They're trying to mask that using the technical language of law. And Burley and Matley, writing about EU law and politics, claim that actually a lot of the European Court of Justice's kind of case law on direct effect and so on was basically masking political choices through law in a very similar way, and often serving elites, quite often economic elites. If you think of Sunday trading laws, for example, and free movement of goods, you're serving interests of large companies that want to keep their shops open on a Sunday, for example. So that's a political choice in many ways. Should a shop open on a Sunday? And yet this is couched in the technical language of, well, this is the free movement of goods. So that's one kind of version of the argument here about elites. And I think you have to distinguish that example of a judicialization of politics there, masking politics through the technique of law, from another type, which is really what I suppose Trevor Allen was more worried about by freeing up standing to interest groups and NGOs, which is that this isn't so much about elites, unless you see those interest groups as elites, of course. But that's judicialization of politics because it's not really hiding politics within the cloak of law, but it's bringing politics explicitly into the legal arena. Okay, so how does that play out in terms of the rule of law? Well, if that mask is working, using the first example, then the courts can be seen to be respecting the rule of law because they are dealing with the law on the free movement of goods, for example. They're not just creating political choices about Sunday trading, for example. But if you pull down the mask, of course, then it can be seen in that way. And therefore you do get into accusations that have been made that what the court is engaging there is actually a government of judges. And that what judges are really doing there is politics. However, they are dressing it up as law. Okay, so I come now to the two cases. The first one was a challenge to EU democratically decided choices about climate targets. And a number of applicants in these cases, in this particular case, the Carvalho case, were not happy with those EU climate targets, thought they were nowhere near ambitious enough, and sought to bring a legal challenge on that basis, which was rejected on standing grounds. The Sabo case, also a climate case, but challenging an EU directive which allowed energy from forest biomass to count as renewable energy under the directive. And that case too was dismissed on standing grounds. So the court in both cases stressed its famous Plowman case, which is a very restrictive interpretation of Article 263 and the idea of when somebody can be considered to be individually concerned in a case. Okay, so what the court was basically doing, to bring this back to the rule of law, was it was adopting a very thin version, to come back to that thin and thick distinction we saw earlier, adopting a thin version of the rule of law, basically stressing those kinds of principles like legal certainty, non-retroactivity. And its argument was basically, well, look, you know, we've had the Plowman case for years. You guys are all used to this. We've been saying this for years. If we overturn it now, where's that going to put us all? You know, that's not great for legal certainty. And the only people that can really do that are the member states, you know, and it's not for the court to suddenly change that. The appellants, in contrast, were arguing for a thick conception of the rule of law, basically arguing that, look, you know, the EU climate law cannot be considered to be in accordance with the rule of law unless it's respecting human rights, fundamental rights. And it falls down on that basis. You know, human rights were a very significant basis for the legal challenge there. And because of that, they said, you know, the measure should be annulled. But the court came right back at them saying, look, hang on, you know, you can't bring that kind of thick argument around rights here because, you know, ultimately you're just trying to undermine that rule on standing that's been in place in years. And we can't allow a rights argument to do that. Okay, so how do we analyze it in terms of the models of constitutionalism? Well, political constitutionalists would obviously emphasize that these EU climate targets, to take the Carvalho case, had been decided democratically by the EU political institutions, and that should be respected. And if we look at a domestic case like the Ohenda case, the Dutch National Court case, the Dutch government was arguing basically pretty much the same thing. The Supreme Court in the Ohenda case disagreed with that and said, look, the protection of human rights is actually an essential component of a democratic state under the rule of law. So them legal constitutionalist position there where human rights are important. Okay, coming towards the end now. I mean, my personal view is that you can support wide-standing and the court changing its mind on a Republican basis. You know, the rule of law is not well served by having narrow standing rules because you're allowing potentially arbitrary action to go unchallenged. The court's response to that, of course, is, well, you know, you have to look at this in the round. And okay, you may lack direct standing before the court, but you can go via Article 267, and that provides you with a complete system of remedies. I think we can debate, and if you look at Gerd Winters, Professor Gerd Winters' great article in the Transnational Environmental Law on the case, he identifies that actually Article 267 really isn't an easy choice to be made there and doesn't offer a great alternative. And therefore, that's not really a great argument. What about populism? Well, I think this is an example where, although the court fancies itself as the people's court, it's not really acting as the people's court at this level. It's not responding to the people's climate case, as the Carvalho case you know, branded itself. The applicants branded it as that case, framed it in that way, in quite a populist way. I think there's a temptation, though, to perhaps argue that standing in cases like Carvalho and Sabo should be dismissed, and this is, you know, a germane argument beyond the EU. Anyone that's interested in standing in administrative law worldwide, you know, this is a relevant argument. There's a temptation to say, look, we're in a climate emergency, so let's be careless with the rules. And actually, yeah, Plowman, yeah, okay, we got to get rid of that because we're in a climate emergency. I mean, that to me is a dangerous route to go down because it is antithetical to the rule of law, I believe. But I think you can have much more of a kind of non-populist rule of law supporting argument for freeing up standing, and that would be the kind of Republican avoiding arbitrary government and freeing up standing for that basis, on that basis. So just to conclude, I mean, I think there's a temptation to see these two cases that really kind of shut down climate change litigation at EU level. You know, the excitement really completely fizzled out. The temptation just to see them as quite technical cases. But I hope what I've tried to illustrate is that by bringing a constitutionalist lens to them and blending that with populism and the rule of law and arguments there, it helps to shed greater light on the case law. Great, I'll finish there. Thank you.
Thank you so much, Chris, for a fascinating insight. I'm particularly struck by the very clear correlation between some of the constitutional principles you talked about and the actual case law. And I was trying in my own mind to sort of strike and build a bridge, specifically, for instance, to what Sanja had talked about earlier with regard on property rights and the conflict in the courts in Serbia. Thank you very much. Thanks to all our four speakers for really wonderfully complimentary papers, and to you for the really good and stimulating questions, and to the organisers for letting me go over by a quarter of an hour. Thank you very much.